Hey there, welcome to another video in this series. In this session, we will discuss various use cases with regards to the post-filing stage of our patent application. Let's go over a few samples to understand what kind of questions can we encounter. Here is the first one. It says A and B are co-inventors of a tracking device. Later, A files an application for a patent in his own name. B comes to know about this fact from the journal of the patent office. What action can B take? So the situation says A and B jointly invented something, but then A decided to file the application on its own without involving B in it. That's a gross injustice, isn't it? If B were to your client and B approaches you, how are you going to help B? So what are the provisions in the Patent Act that you can use to help B either obtain the patent on his name or include B's name as inventor in the patent application, or worst, get A's patent invalidated using various grounds available in the Patents Act. We'll discuss the approach in detail as we go through the slides. Let's have a look at another use case. A big one, but it's just a story. So Raja and Radha did their PhD together. After completing their doctoral program, they planned to set up their own lab with a loan from a bank. They started working on a novel dermal application which will heal severe burn wounds and will grow the skin back in a short time. And no such dermal application was known in the prior art. So they provided details about invention, and they being the joint inventor. In the course of their working together, they came to view, based on their compatibility in professional interest and other issues, they will get married. Good. They jointly filed for a patent and also received the patent in 2009. Another development. Raja promised her that if they license the patent, Radha can take 75% of the profit as he cared for her. Okay. They have an offer for a license for this patent from a company for a hefty amount. In the course of next few months, they developed differences in their relationship and eventually decided not to marry. Sad. After some time, they bitterly quarreled and decided to part ways. Not good. Radha approaches you and complains that Raja is retracting from his earlier promise to give her 75% as promised and say that he will give only 50% of the amount. Further, she states that Raja also wants it to be licensed to another friend of his who is offering a lesser license fee, which is not acceptable to her. She approaches you for a consultation on the above issue. See, they created so much of story around it. But finally, what's happening is there are two major issues that we need to address in this question. First, can the license be given without the consent of all the co-inventors? Second, how much profit margin is legally acceptable? So there are provisions available in the Patents Act to deal with both these use cases. Section 20 talks about how the license can be provided and how the license should not be provided. And Section 50 talks about the rights of co-owners. Using the details provided in Section 20 and Section 50, you can provide your consultation to Radha about how she can go through such situation. So coming to the objective of this session, how do we approach the questions? So as to say, how do we decode the question? Now, based on our discussion around the previous use cases, we understood that there is always a relief that is sought by the client, and there are some constraints given to you, right? Now, there could be dispute between the applicants, because of which there is a relief sought. For instance, your client may want to oppose the patent or the application. Now, by opposing the patent, the client may want to completely get it rejected or invalidated, or obtain the patent on her name, or by mentioning his name as the inventor, right? Now, what are the constraints that we are talking about? Now, constraints could be, what are the reasons for dispute? Based on the reasons of your dispute, you decide what relief can be sought. Also, how much time has elapsed from, let's say, the grant of the patent or from the filing date of the patent. Depending on this, you can identify the options which are available to you. Right? Few options are available before grant, few options are available after grant, only for certain time duration. So we know how to read the question. How do we answer the question? How do we code the answer? Right? So as earlier, we always start by mentioning our understanding of the objective. our understanding of the relief sought by the client. This is one of the ways of doing it. The client wishes to the relief that is sought and why, the reason because of which the dispute or the reason because of which the situation has arises. After this, you write the section numbers that you are going to invoke to let the client know that there are the provisions available for you to seek the relief as per the provisions contained in those sections. Right? Here is one way you can write your answer. As we know, section 20 or others based on the dispute and objective of the Patents Act provides a provision for again the objective. Therefore, the client can approach the controller court as per section to invalidate the patent or to request that the patent be named after me because it was wrongfully obtained by me. This is how you start your answer, by providing your understanding of the situation and what provisions are available to seek the relief that the client wanted. You need to build upon it by providing the entire process as per the section that you have identified. How do we do so? So let's say you have identified few of these sections, could be 20, 25A, 25B, 26, 28, 50, 51, 64. These are the major sections which are applicable for post-filing disputes or post-filing scenarios that are there, right? Or post-grant also at 25B for that reason. So you need to describe the entire process using the forms, timelines, and fees associated with it. You need to provide the reasons and grounds for the objections that you have. You also need to provide supporting documents and details and what is the relief that is sought, right? And remember, there could be situation where you can provide multiple options to the client. So remember and read the objective clearly to understand if you can use one or more of these options and accordingly provide the details around it. Ready to test your knowledge on few of the use cases? Let's get started. So here's the first one. A leading natural product specialist, Leelavati, on her return to India, set up a new institute called Herbal Advanced Research Institute in Lucknow, researching in natural products. She filed a patent application in India jointly with her colleague, Dr. Pratibha, for a herbal composition for water purification and called the product Pani Pure. They were granted a patent for Pani Pure as inventor applicants in 2010. Dr. Pratibha left Hari and joined a water treatment company, AquaTreat, in Jammu, to whom she licensed the patent. Okay. AquaTreat started marketing the product. Leelavati got to know about this development from the local newspaper. She has approached you for advice on steps she can take to protect her interest. Long story short, what is the objective? There were two inventors. They were the applicant of the patent and the patent was granted on their names, right? So we have section 50 that talks about right of co-owners, but we also have section 20 that talks about on what grounds a license can be provided to a third party. The license cannot be provided to a third party without consent from each of the co-owners or co-inventors, applicant in this case. So mention your understanding, mention the constraint. What is the relief that is sought by it? Relief is license should not be provided, or if license needs to be provided, she needs to be party to the license agreement, something of that sort, right? And develop the story, provide the forms which are required as per section 20, provide the timelines, and go about explaining the case. Moving to the next one. Messrs. Alpha Pharma received patent rights in India for a novel compound B, claiming priority from 2002. Patent grant notification was made in official journal on 2006. Okay. Beta Pharma, your client, on seeing the notification, is of the opinion that the compound B was imported to India on July 2001. Okay, and being commercially sold at all places from August 2001. Beta Pharma approaches you on 1st March 2007 for necessary advice and suitable actions to be taken. Interesting case. So a company has obtained a patent. Another company says that they should not have obtained the patent because the product was already available at commercial scale before their priority date. So mention your understanding. And what is the requirement? The patent should be rejected. Patent should not be allowed. But the patent is already granted. So which scenario we are in? Post-grant opposition. Now the grant date was 1st July 2006 and Beta Pharma has approached you on 1st March 2007, which is less than 1 year from the grant date. So you can still go for post-grant opposition section 25B. Use the forms, use the grounds. Grounds is already available in India before the filing date of the first application. And what is the relief sought? Invalidate the patent, basically. Reject the patent, right? Let's move on to the next one. A patent application relating to an antihypertensive agent has been published in the journal on 12/11/08. Your client is already manufacturing the said drug since 15/6/2006. Again, a similar case where a patent application has been filed, but then the invention or the product is already available in the market, right? So in this case, because this is patent application, which is yet to be granted, therefore you go for pre-grant opposition. Mention the section numbers, mention the forms, mention the timelines if there are any, and grounds. On what ground are you wishing to oppose the patent application, right? Moving to the next one. Your client X has been manufacturing a compound since 1/1/2004, but one fine day on 5th January 2007, he gets a notice from Mr. Y that he is infringing his patent. Take action to protect the interest of your client. Now, in this case, we are actually not sure when was the patent granted. If the patent has been granted recently, we will go with post-grant opposition within 1 year, or we will go for section 64, revocation of a patent. You can mention your understanding, mention the relief sought. Relief is to oppose, invalidate the patent, identify the sections, identify the grounds, define the process, and go ahead. Moving to the next one. Your client ABC partnership, where partners are P, Q, R, informs you that their competitor XYZ application for patent has been notified as accepted under patent specification number, dated this. They wish to file opposition to the grant of patent. Now here also, depending on what date we are on, we can file post-grant opposition within 1 year from the grant date, or section 64 anytime after grant. Define the grounds, define the relief that you are seeking, what forms are you using, and what process you would go with the sections, either section 25B or section 64. Define the process and keep going ahead with it, right? Next one. Your client informs you that he has received a notice of infringement from Mr. A with respect to an Indian patent granted recently. He also informs you that he is working the invention claimed in the said specification for the last 20 years. So again, same use case where there is a potential infringer and there is a patentee. Now here they have talked about recently granted. It means we have to take the provision of section 25B, the post-grant opposition. What could be the ground? The client has been using the invention for last 20 years. It means the invention was already available in the public domain. Therefore, it should never have been granted. You provide your grounds, you provide your evidences, and you provide your statement. Explain the process, create a flowchart if you can, and create the storyline for your answer. Moving on to the last use case. The director of company X had filed an application. After 6 months of filing, company X was acquired by company Y, and the director has approached you to handle the further prosecution of the case. Explain what steps will be taken by you. Now here it's a simple case where company X has been acquired by company Y. Therefore, the intellectual properties of company X also will be transferred to company Y. So this is a case of reassignment where company Y's name should be incorporated as the applicant, as the assignees on the patent application. Now for you to represent company Y, you also need to have power of attorney on your name. So you can use section 6 for requesting the controller to change the assignee name from company X to company Y. And the evidence that you would file would be the evidence which could state that company X has been merged in company Y. There are government issued documents which can be used for it. So with this, we have covered various use cases in the post-filing stage of our application. Most of these deals with the disputes, could be between the inventors or disputes between multiple parties, the competitors, and either you need to help the inventor to get the patent on their name, or you need to help one of your client to either prove the infringement, or prove that there is no infringement, or prove that the patent is invalidated, or patent should be rejected based on multiple grounds, right? But you need to understand, do you want to invalidate the patent, or do you want to get the patent on your name? As per the objective and requirement, you will identify what sections you want to pursue and what kind of relief you want to obtain for your client. So that's all for this part of the video. In the next video, we will discuss few use cases regarding the compulsory licensing provisions of the Act. Till then, be good and take care.